If I go on garden leave during my employment, might that have an impact on the restrictive covenants that I'm bound by? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. The answer to this question is maybe. The reason for that is that your employer might put a clause into your contract of employment or into an employment-related settlement agreement that it's offering you that essentially says that the lifetime of the restrictive covenants is reduced by the amount of time that you spend on garden leave. So let's say, for example, that you have restrictive covenants in your contract of employment or a settlement agreement. Let's say that you have a non-poaching clause to not take your employer's clients with you for 6 months after you have left their employment. But on top of that, there is a clause saying that the lifetime of the restrictive covenants will be reduced by the amount of time that you've been on garden leave, if you're put on garden leave. Now, let's say that your employer puts you on garden leave for 3 months before your employment ends. The practical impact of that is that it reduces the amount of time that non-poaching clause applies from 6 months to 3 months from the point where your employment ends. So it's a big practical difference. It's also optional for your employer as to whether it actually puts that into the contract of employment or the employment-related settlement agreement, whichever applies. However, I'm sure you'll agree, it's a very interesting situation that could arise for you. However, I hope that's answered the question. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.